Assalamualaikum. My name is Muhd Raziq bin Azni, number ID MDA 22070017. Now, I will talk about question 1B. For this case, the legal issue is whether Faris, who is in a part of partnership firm that selling premium car tint and car detailing, he want to open his own business that offering similar products. The legal rule for this case is Section 32 of Partnership Act 1961, which outlines the duty of partners to account for profits from competing business. The meaning of legal rules. Section 32 of the Partnership Act 1961 states, if a partner engaged in a business with the same nature and competes with the partnership firm without the approval of other partners, the partner must pay all profit made from his business to cover the firm losses. There are two conditions for this section. The business must be of the same nature and must compete with the partnership firm. Second, the competition must be with express or implied consent. So, this section serves to prevent partners from duty of partners to account for competing business. Refer to case AS vs. Benham. His Clarkson and Company was a partnership firm of shipbroker. The defendant, Benham, was one of the director of the company. One day, Benham wanted to do his own business as a ship owner. He wanted to use name H. Clarkson and Company, ship owning. Other partners of the company were very angry after know about this. The Court of Appeal was held that the defendant cannot use the same name for his own business. Since the defendant was beyond the scope and considered as not competing with his partnership firm, the defendant was not liable. Lastly, analysis of the outcome of the given situation. First, Faris has breached the duty of partners to account of profits from competing business. Next, Faris breached the agreement by running a competing business without his partner consent, which could risk the partnership firm customer base due to his lower prices. Next, Zack and Jason have the option to sue Faris for violating the terms of the partnership under Section 32 of Partnership Act 1961. And last, Zack and Jason are entitled to terminate Faris' contract and claim compensation for any loss incurred. I think that's all for question 1B. Thank you.
Now, I will be presenting about identification and justification of legal issue and legal rule. The issue of this case is whether Ali's action was right or wrong, and he must first get Ramesh and Chong consent to dissolve the partnership or not. The issue arises because Ali stated in the notice that the partnership business will end on the date mentioned in the notice, which was 1st October 2022. And that there will be no more partnership business between Ramesh and Chong. The legal rules that are closely related to this issue are Section 34 Clause 1 Clause A and Section 34 Clause 2 of Partnership Act 1661. According to Section 34 Clause 1 Clause A of Partner Act 1661, it stated that a partnership is dissolved if entered for a fixed term by the expiration of that term. It means it will automatically dissolve when that period that they agree upon have expired. And according to Section 34 Clause 2, it stated that the partnership is dissolved as from the date mentioned in the notice as the dissolution. Now, explanation of the relevant reported case on point. The case that are closely related to this issue is the case of Tam Kok Cheong and Ors versus Lau Pui Hang. In this case, a firm made up of four partners was dissolved with the sale of the firm to a limited company. Despite that, three of the partners negotiated for the sale of the firm without informing the fourth partner. He only knew of the dissolution of the partnership on the date of sale of the firm on 6th of April 1666. Of the fourth partner alleged that he had not been given on the dissolution of the partnership. The court held that the conduct of the other three partners in selling the firm to the limited company must be considered as showing their intention to dissolve the partnership, as the fourth partner only knew as the sale on 6th of April. The intention to dissolve is considered as having been conveyed and take effect from that date. Of the given situation, On 5 July 2022, the partnership become to end, but the partners agree to continue the partnership until 1st October 2022 via issuance of a notice. It shows that the partnership is not considered as partnership at will because the partnership is still had a fixed date that the partnership will dissolve. Next, Ali further stated in the notice that the partnership business will end on the date mentioned in the notice, which was 1st October 2022, and that there will be no more partnership business between them. It showed that partnership will automatically dissolve on 1st October 2022 because according to Section 34 Clause 2 of Partnership Act 1661, it stated that the partnership is dissolved as from the date mentioned in the notice as the date of dissolution. In conclusion, Ali had right to do that action and he didn't have to get Ramesh and Chong consent to dissolve the partnership.
Okay, now I will be presenting about question number 3A. Identification and justification of legal issue and legal rule. The legal issue is whether a partnership automatically dissolves when one partner dies or if it can continue with the existing partner's consent. This arises due to the death of one partner and the existing partners argue if they can continue the partnership based on mutual agreement. This issue is according to Section 35(1) of the Partnership Act 1961 govern this legal rule. Next, the meaning and context of legal rule. According to Section 35(1) of the Partnership Act 1961, every partnership is automatically dissolved upon to their partner death or bankruptcy, but they can still continue their business if it's stated expressly at their partnership agreement, and all of the existing partners agree to continue. The agreement must be made before the death of the partners so that existing partners can continue the operation of business. And if the agreement no longer valid, the partnership needs to be dissolved. Next, explanation of a relevant reported case on point. Refer to the case of Yam Holdings Sendirian Berhad and Ko Yok Wah and ORS 1990 to MLJ 431. The plaintiff claimed that the partnership dissolved because Lee, the senior partner, died in August 1988. The plaintiff and the defendant were a partnership of a jewelry company. Despite the fact that Mr. Lee's wife wished to remain on the business in his place. Even so, an agreement made after the death of a partner will not have any legal effect because it is without the consent of a deceased partner. The respondents claim that because the partnership was dissolved by Lee's passing, the widow was unable to continue it. According to the court's decision on Section 35(1), the partnership agreement not to dissolve upon the death of a partner had to be formed prior to that partner's passing. An agreement formed after a partner's passing won't affect the firm legally. As a result, the partnership will dissolve and cease to exist. For the last one is analysis of the outcome of the situation given. According to Section 35(1) of Partnership Act 1961, a partnership dissolves when a partner dies. However, if the existing partners agree to continue and is stated in the partnership agreement, the partnership can still continue. In this case, Faris wanted to dissolve the partnership due to Sheila's death, but Amir argued that the partnership agreement allows for it to continue, as long as all existing partners, which is Amir, Faris and Yusri, agree. The partnership can continue despite the section of 35(1).
Identification and justification of legal issue and legal rules. The issue is whether the partnership between Salman and Halim towards Zaidi's case cannot be dissolved to conduct prejudicial to the partnership business and can be continued. The dissolution of their partnership business will not dissolve because Zaidi case is not related to company economy and just sued by police traffic violation went viral. Zaidi case can be sued under personal only and not involve partnership to settle. Although Zaidi was doing mistake and be sued, he still in a part of partnership business with Salman and Halim, but just the image of them is being bad. So the partnership remain maintained like usual. The meaning and context of legal issue is according to Section 37C of Partnership Act 1961 under resolution by order of the court. When some partner has been guilty of conduct, the decision of the court must regarding to the nature of business, so the effect prejudicially to carry on the business. The prejudicial conduct is directly or indirectly related to the partnership business. If the partner do the conduct such as simply bad behavior but must indirectly or directly due to the partnership business policy, so the court may not consider the application to dissolve the partnership. Then the conduct prejudicial must related to the finance position or will make the firm shut down such as affect the bank's credibility only. For the explanation of the relevant reported case on point. From this situation, the related case under conduct prejudicial to the partnership business is SL and Howard 1860 30 BF 158. In this case, a solicitor used the client's money for his own personal needs that was entrusted by the client without knowledge. The solicitor, which is the plaintiff and defendant who are doing partnership business together. The defendant had sold out trust fund surviving trustee to the amount 8,000 euro used for his own needs. The partnership account had been paid and brought out by the defendant and claims were made in partnership. The court held that such the behavior amounts due to the prejudicial behavior such it affects the credibility of the firm, so the partnership will dissolve immediately. Analysis of the outcome of the situation. In conclusion, the partnership will dissolve due to the conduct prejudicial to the partnership business in dissolution by the order of the court. This is because I did not do conduct prejudicial related to the financial position or will affect the bank credibility of the firm. So Salman and Halim cannot dissolve the partnership of the business due to the decision by the court.
Assalamualaikum warahmatullahi wabarakatuh. My name Muhd Zikry by Mazawi, MDA 2207068. So I will present about question 5A. Firstly, identification and justification of legal issue and legal rule. The issue is whether the partnership between Jojo, Ravi, and Danny has been cancelled due to a change in the law that caused their nature business to be unable to continue. The change in the law in Johor changed when the state government of Johor passed a law that regulates that any business related to HA-grade products will not be allowed to operate. Second, the meaning and context of legal rules. According to Section 216 of the Partnership Act 1961, under dissolution by illegality of partnership, every partnership will dissolve when they have a business nature that is no longer legal under the law. A business can be illegal when the nature of the business is no longer allowed to be sold because it is illegal. If the partnership continues, the partnership will be void. Third, explanation of a relevant reported case on point. The related case under illegal partnership dissolution is R. V. Cooper, 1915, 2KB 321. In this case, the defendant was a partner in a firm with two of his father. Partnership business is conducted in Frankfurt and London, and suddenly war declared. One of the issues which was the whether the partnership had been dissolved by outbreak of the war, and it was held by the court that the partnership was dissolved as soon as war was declared. 4. analysis of the outcome of the situation given. When a law has been changed that causes their nature business to not operate, the partnership involved will automatically be dissolved. They can continue the partnership by changing the nature of the business before the new law is implemented. So the partnership is automatically cancelled because the nature of the business is no longer legal to operate. And they can still make a new agreement if they want to continue with natural business. And lastly, Jojo can claim the capital that he had invested in the partnership business without any obligation for Ravi and Danny because the partnership is automatically dissolved. So this is just me. Thank you.